Okay, the Board of Direct Entry and Midwifery Rules Advisory Committee meeting is convening at 9:10 a.m. on September 14th, 2022 at the Health Licensing Office in Salem, Oregon by telephone conference call. I will now call roll. Silka Akerson,
Here.
Hermine Hayes Klein,
I'm present.
Lennon Clark,
Here.
Nora Hawkins,
I'm here.
Willa Woodward,
I'm here.
and Donisha Stone.
Here.
Okay, members, when you wish to speak, please state your name, your last name for the record. Committee members are asked to not use the chat feature during the meetings. Public members wishing to speak must first sign in the roster or email april.fleming@dhsoha.state.or.us. Provide your first and last name. Public and interested parties feedback may be heard during the public and interested parties feedback period if indicated on the agenda. Everyone is asked to use appropriate language, manners, and protocol when conducting board business. This meeting is now called to order. Okay, so good morning, everyone. Glad you guys could make it. Appreciate your time, giving this time and your willingness. So we're going to do introductions real quick. I'm Sammy Patno, the policy analyst for the Board of Direct Entry Midwives. I've been here 25 years. I've seen a lot of things happen with the midwife program. It's one of my favorites. I know that's some people, anyway, one of my favorites, and we're excited to get this going and make this happen. So Silka, you want to go first?
Sorry, still getting used to where the unmute.
Yeah.
I'm Silka Akerson. I'm a licensed direct entry midwife and a home birth midwife in Portland and the executive director of the Oregon Midwifery Council.
Willa?
Good morning. Willa Woodard Irvin. I'm a licensed direct entry midwife, Southern Oregon, and I own Rogue Birth Center.
Hermine? Hermine, you want to introduce yourself? You're muted. I know it's hard to get used to. Well, we'll come back to Hermine. Lennon?
Sorry, trying to get my camera on. Hi, my name is Lennon Clark. I'm a licensed direct entry midwife in the Salem area.
Nora?
Hi, good morning. I'm a licensed direct entry midwife and lactation consultant in Wallowa County, which is almost Idaho, the very northeastern corner of Oregon. And I just go to Union County and Wallowa County, so about an hour and a half radius.
Great. Someone from the sticks. We always need someone like that. Donisha?
Good morning, I'm Donisha Stone. Oh, my camera's, it's connecting. Hold on, folks.
We can see you.
You can see me?
Yep.
I can't see you. It's so weird. Good morning. I'm Donisha Stone with the African American Immigrant Outreach Program with CPOP, statewide policy analyst.
And Hermine, are you back? Can you introduce yourself? Hermine is an attorney, and I believe she represents the Oregon Birthing Center Council. So when she pops back on, we'll have her introduce herself. So the agenda is going to go what we just did, and then our attorney, our senior attorney, is going to give us a little tutorial on how rules advisory committees work, how laws equate to rules, and how all that works. And then we're going to look at the draft text on the peer review rules, looking at defining an entity, chart reviews, number of professionals that would be in attendance at those, just kind of everything involved in the peer review, and trying to make that clear for the LDMs so that they can make sure that they're meeting all the requirements. And that may go quickly, it may not, I don't know. We've given you several options, so we'll just talk through all of those. Then we'll talk about the indication for transfer-antepartum and the intrauterine growth restriction versus fetal growth restriction, Then we'll talk about adding the TXA to legend drugs and devices. Then we'll go over fiscal impact and how any of those rule changes impact small business, the public, LDMs, state agencies. And then if there's any recommendations the committee needs to make, and then we'll go over the rules timeline and then have public comment. So if no one has any questions about that, then I will turn it over to Heather Vogelsong to give her presentation. And Heather, will you share your screen?
Yes, I will, Sammy.
Great,
Thank
thanks,
you.
Heather.
Yes. Hi, my name is Heather Vogelsong. I'm an attorney with the Oregon Department of Justice, and I provide assistance to HLO and its many boards and programs. I go by she and her pronouns. I'm happy to be able to give this presentation to you today, which is an overview and hopefully will center us all on the same page, since we all come from different backgrounds and different levels of knowledge about how government works, about how these RAC committees work, and also of the statutes that guide the direct entry midwifery program. This may be some additional information for new people. For others who are licensees who have taken the laws and rules exam, some of this may seem repetitive, but hopefully we'll be able to pull us all together so that we all have the same basic knowledge. I'm going to share my screen and pull up a presentation for you. Get that. Sammy, are you seeing the presentation?
Yes,
Yes.
Heather, we can see it.
Okay, thank you. So the first slide should state Rules Advisory Committee Training. And hopefully you're all seeing that, and hearing that you are, I'll move forward. Okay. Okay, so as you know, there are three different branches of government: the legislature, the executive branch, and the judicial branch. And they have different functions within our government. The legislature makes the laws. They make what's called statutes. The executive branch carries out the laws, whether those are statutes and rules. Rules are things that we'll be talking a lot about today. And then the judicial branch interprets the laws. So what are statutes? The legislature is the branch of government that makes the statutes, and statutes are laws that are enacted or which is created by the legislature. These are the governing structure for the Direct Entry Midwifery Board, for HLO, and also for its other boards and programs. What's important to know is that agencies only have the powers that are given to them by statutes. And this is also for the board itself. For the Direct Entry Midwifery Board, only has the power that is given to it in statute. And so that is why we look to the statutes when we are working on rules in rules advisory committees. So the court, which interprets the laws, they have said that a state agency has no inherent power, but only such power and authority as has been conferred upon it by its organic legislation, which again are the statutes. So then we ask, what are rules? And again, rules are laws that are promulgated or created by agencies, and they are laws that interpret what the statutes say, or they more fully explain what the statutes say and give further direction. An agency's power to create the rules is grounded in its governing statutes. And that is something, again, that the courts have told us, is that the rules have to be based on statutes, and the statutes are what the legislature created. So there's a whole structure for how rules are created. So the court has said that an agency, which is a creation of statute, has no inherent power, but only such power and authority as has been conferred upon it by its organic legislation. Again, those statutes. The power includes express conferred authority by statute. So if the statutes specifically say what the authority is, but they also have implied authority, which is the authority that is necessary to carry out the power that is expressly granted. So stated somewhat differently, a statute which creates an administrative agency or a board and invests with it the power is likely the measure of its power as well. So these are principles that we look to when we are looking at creating rules. So what you will hear today during the RAC are some different acronyms. So I wanted to go over those acronyms really quickly. The ORS is the Oregon Revised Statute. So those again are the laws that the legislature creates. ORS, Oregon Revised Statute. The OAR are the Oregon Administrative Rules. And those are rules that you will be discussing today. And those are the rules that then further carry out what the statutes say. And so when you hear OAR, it is a rule. When you hear ORS, it is the statute. So when enacting rules, an agency must look to the authority that is given to it by the statutes. What authority is there that the legislature has said an agency or HLO has, and then what can be based in rule off of that? How do we know what the statutes say? Well, there's a whole process that the courts have set out for us as to what we look for in statutes to be able to determine what we can do in rule. Part of that is that we look at the different terms or the words that are used in the statutes, and we identify whether those words are exact terms, inexact terms, or delegative terms. And I'm going to go through each of those so that you have a sense of what a statute might say and where then there is authority to do more in rule or not do more in rule, again, as the statutes would allow. So first, exact terms. Exact terms are words of precise meaning. And we know that when a statute has an exact term, we know exactly what the legislature meant. And the board and HLO and a RAC cannot change those terms in rule because they have an exact meaning. The legislature has told us that. Some examples are 21 years of age. If a statute says you have to be 21 years of age to do something, a rule cannot say that a person can be 22 years of age or 18 years of age. It's an exact term. The legislature told us exactly what it meant. 30 days is another exact term, and Marion County is another exact term. All of those are very precise. They have precise meanings, and we can't change those by rule. A statute may also have an inexact term. An inexact term is a word of less precise meaning, and it requires agency interpretation, and that is done through rule. So the word has different possible meanings and different possible interpretations, and then the rules set out what that interpretation is. And the agency's goal when identifying and interpreting these inexact terms is to do what the legislature meant, to do what the legislature intended. And the cases have told us that an agency may express which interpretation it is effectuating through the statutory policy, either by rule or in a contested case. And a contested case is when a person goes through a hearing and then there is the opportunity to lay out what the meaning of a statute is during that hearing process and that contested case process. But we're focusing on here the rulemaking process. And so what the RAC and the board can do here is to effectuate the statutory policy, looking at what the legislature intended and interpreting in rule what the statutes mean. So some examples of inexact terms are the words employee, weapon, and wildlife. Just to give you some further examples as to why those are inexact terms. Wildlife can mean many different types of animals. It could mean a deer, it could mean a rabbit, it could mean insects. So there's a lot of different types of wildlife that would be included within that word. And then the rules would express the type of wildlife and further provide the intent of the legislature with that word. Similarly, the word weapon. A weapon could be something such as a gun or a knife or a sword. It could also have a different meaning, such as a lead pencil or a pen. Is that what the legislature intended? We would look at the statutes to determine whether something that could be used as a weapon, such as a pen or a pencil, is what the legislature intended in the statute, or whether they meant something more like a gun or a sword. So those are words of inexact terms, and that's what we use rules to do, is to flush out those inexact terms. There's also something, I'll get to delegative terms in a moment. So how does the agency figure out what the legislature intended in order to be able to go forth and rule and say what these inexact terms are? Well, there's a three-step method that the court has told us to use. First, we look at the words of the statute, we look at the text and the context, and this is given primary weight when we are interpreting a statute. We look at the words, the specific things that the legislature has told us through the specific words that they use and the context and how they use that word within the statute. Another thing that we do is we look at a legislative history. So we look at the process that the legislature went through in creating that law. We look at various versions of the bills before it was passed into law. We look at what legislators said about the law when they were considering it. We also turn to different exhibits and different comments that were made during the legislative process. So we look at legislative history. And then after those two steps, if the intent is ambiguous, then we turn to general maxims of statutory construction to clarify the intent. And those are rules that the courts have said we can use when we're looking at interpreting statutes, and they can give us some direction as to what the legislature meant when we're interpreting. So that's the process that we use. You're not going to need to go through that today, but I wanted to give you a background as to how we come about finding out what a legislature intended so that the RAC and the board can go forward to make rules. So next we'll turn to delegative terms. And this again is the third type of term that we could find in a statute. Delegative terms, are those terms that express non-completed legislation in which the agency is given delegated authority to complete. So this is a situation in which the legislature has actually said, go forth. We are passing the baton. We're letting you go forth in rule and explaining what the rule of law is going to be. And here the example is from the cosmetology statutes. This is a very clear delegative term. And in this statute, the legislature has said the device has the meaning given that term by the Board of Certified Advanced Estheticians by rule in collaboration with the Board of Cosmetology. So here the legislature, our lawmakers have passed the baton to the two boards and said, go forth, make rules, and define what device means. So that's very clearly giving that authority, that rulemaking authority to define a specific term in rule and giving that to the boards. So that's very easy for us to say, okay, we're going to go make rules with that. So important to know with all of these terms, even with delegative terms, the ones where the legislature has passed the baton, important to that is that the agencies and the boards must always stay within the intent of the legislature. And that was what I had just mentioned before in regards to figuring out what the intent of the legislature is. So an example here is that the legislature may set forth a statute that says agencies we would like you to create an animal. And in creating that animal, we are going to give you the bones of a dog. So they give you the bones of a dog, and you could, in rule, then go forward and make rules about a poodle. You could make rules on with those bones on a Doberman Pinscher. You could make with those bones a Saint Bernard. So all of those are within the legislature's intent of making an animal and using the bones of a dog. But what you couldn't do is make, with the bones of a dog, you couldn't make a cat, because that's not what the legislature intended. They gave you the bones of a dog, and you can't create a cat with those bones of a dog. So that's a very simple example of just staying within the legislature's intent of what they give you. And if you refer back to that when you get stuck as to what you can do and can't do, just remember you can make the dog, but you can't make the cat when you're given the bones of the animal that the legislature told you to do. Okay, so with that in mind, general overview, we'll go through what the rulemaking process is so that you have a sense of what your job is here today, and then also so that you know what happens after this. So this is in a nutshell, because the rulemaking process can be more complex. The rulemaking process for HLO, and especially for these rules, involves a RAC. A RAC is a Rule Advisory Committee, and it provides advice and recommendations to the board for the board to then be able to go forth and make rules. After the RAC, then the rules are drafted in a proposed form. What Sammy has done for you today is she has also provided you with proposed rules for your discussion. So you have, as RAC members, you have proposed rules to think about and work with today. But then after Sammy gets your recommendations today, then another draft of those rules will be created so that they can be presented to the board for the board to consider. Then those draft rules, after considered, they are filed with the Secretary of State, and notice is given to interested parties. So that would be notice is given to people who would be interested in these types of rules, so that they can then comment on the rules. And that's the next bullet point. So the public is given an opportunity to comment on the draft rules before they actually become part of the laws of our state. And that way, further feedback and information can be received by anyone who is interested and is wanting to comment. So after that process, then the board or the agency considers the public comment. They discuss the rules, the draft rules at issue, and they determine what the final rules are going to be. So normally HLO's process is to have the board consider the draft rules before they are presented and filed for public comment. Then after receiving that public comment, HLO then gathers all that information, presents it to the board. That way the board has the public comment and the draft rules, can make any further changes based on their considerations of the public comment, based on the draft before them. And then there's a final determination of what those rules are going to be. And then that final draft is filed with the Secretary of State, and then they become the rules that are governing the governing law along with the statutes. So that's the process in a nutshell. And you are at the beginning stage. As you can see, you're right at the top, providing the advice and recommendations as this rulemaking process gets started going forth. So what's the purpose of a RAC? What's the purpose of a rulemaking rules advisory committee? The purpose is for public involvement, to be able to get individuals involved in the rules and to represent the interests of persons and communities that are likely to be affected by the rule. Trying to make the rule the best type of rule that it can be, trying to get all of those different perspectives involved to be able to make the best rule possible. So the RAC provides advice and recommendations on the draft rules to the board and to the agency. So that's what you'll be doing today, is going through those draft rules and then relaying your experience, your perspective, and giving that advice and that recommendation. The RAC provides recommendations and information that the board and agency can use for the fiscal impact statement and the racial equity statement. So that's an additional role that you'll play today, is giving your advice, giving your recommendations as to what should be included in the fiscal impact statement, and we'll talk a little bit more about that, and also what's included in the racial equity statement. We'll talk a little bit more about that too. And then also to know is that the RAC is held in a public meeting. That way the public has access to this rulemaking process and can hear the different perspectives and can hear the different recommendations and advice that you give. So we're going to jump really quick to what is a public meeting, so you have that information. But again, this is just a layout here on this slide as to what your purpose is today, why you're meeting today. So the basic requirements for a public meeting, I'm going to go over this real quick because these are all things that HLO takes care of for you so that you don't have to worry about this. But just know that this is a transparent process. So notice is given to the public about the meeting to tell the public that this meeting is happening. The public is then able to access the meeting, including individuals with disabilities are given ways to be able to access the meeting. So again, being able to get input from all different people. The meeting must be either recorded or minutes must be taken. So there has to be some sort of log of what happened during the meeting so that it can be referred back to. And then there is a vote on official actions that are taken. So those are all things that happen at a public meeting. And again, this is something that Sammy will walk you through, and HLO and Sammy have taken care of on your behalf. But just know that that's part of this RAC process, is that it is a transparent process so that the public knows what is going on. Okay. Next, we're going to turn to the fiscal impact statement. So as I said previously, one purpose of having a RAC is to be able to get your input for the fiscal impact statement. So the Sammy and HLO will be asking for your recommendations on whether the rule will have a fiscal impact. And so what are the monetary impacts that the rule would possibly have? And what is the extent of that impact? So that's something to be mindful of, thinking of as you're talking about the rule. And then towards the end of the meeting, Sammy will ask for your recommendations and your thoughts on the fiscal impact. And so be thinking about that as you're going through your discussions. So one of the recommendations Sammy will ask for is whether the rule will have a significant adverse impact on small businesses, and if so, recommendations for mitigating the cost of compliance. And that's an important piece to know, to try to help out those small businesses by mitigating any economic impact on them. And this is where your firsthand practical knowledge comes into play, and where you can really provide some input as to what you think that impact would be to be able to help the agency minimize that impact. So that's a fiscal impact statement. Also, in addition, as I'd mentioned before, one of the purposes of the RAC is to provide information to HLO and to Sammy on the racial equity statement. So a racial equity statement is a statement identifying how adoption of the rule will affect racial equity in the state. So HLO will be asking for your information on to be able to help it create this statement when it does the rule filing. So when you're thinking about this, here are 7 different items to consider to help you think through what the racial equity statement information would be. What types of recommendations is HLO looking for? What type of information should you be thinking about as you go through your rulemaking process so that you can provide recommendations to HLO? So first, what racial groups will be affected by the rule? So you have 3 different aspects of the rules that you'll be considering today. So you'll want to think about each of those three and think about what racial groups would be affected by the rule. When you're thinking about legend, drugs, and devices versus when you're thinking about the peer review statutes, how do those impact racial groups, and do they impact them the same or differently? But to be thinking about that. Number two, which racial groups are likely to be most concerned by the issues addressed in the rule? Same type of information. Who's going to be interested in this rule? Who's going to be impacted? Who's going to be concerned? Three, which racial groups are likely to be most affected by the issues addressed in the rule? Again, trying to get at that information. Four, if current stakeholders do not represent the racial groups likely to be affected by the rule, then who can HLO contact that represents racial groups likely to be affected by the rule? So if you think that there are additional groups, individuals that need to be consulted, this is where you can provide that input to HLO and say, hey, I know of this group, they're likely to have an interest or they're likely to be affected by the rule, and here's a group that you can contact to get that information. Really giving HLO those resources so they can go out and find what that racial impact will be. So if you don't have the knowledge and the information yourselves, provide those recommendations to HLO to be able to go forward. So number five, identify other resources where HLO can find data that helps to determine racial equity impacts specific to this rule. Again, finding resources, recommending resources to HLO. Your thoughts on how the rule might impact those racial groups. So not just thinking about who would be affected by the rule, who would be concerned or most likely affected by the issues addressed in the rule, but your thoughts on how the rule will actually impact those racial groups, and providing that input to SAMI and HLO so that they have that information, as well as your thoughts on any unintended adverse consequences that the rule might have on a racial equity. So what are unintended adverse consequences that come to your mind when you're thinking about these rules? So, and providing that information to HLO. So when we say racial equity statement, these are the types of things to be thinking about, and the types of resources and information that would be beneficial to HLO. Okay, so that was the rulemaking process, the purpose of the RAC, and going through what a public meeting is and the types of information HLO would like to have from you today. Next, what we're going to do is turn to the statutes, the direct entry midwifery statutes, and talk about rulemaking authority, and talk a little bit more about the statutes that you may hear about today, and that will provide some guidance so that as you make rules, you know what those bones are as you create your dog and not your cat today. Okay, so starting out, who has rulemaking authority? So the statute states that the State Board of Direct Entry Midwifery shall adopt rules for the administration of the direct entry midwifery statutes. So the legislature has told us that it's the board who has rulemaking authority. So again, as we went through the process of the rules, the RAC provides that input, those recommendations now, and then ultimately the direct entry midwifery board will have the final rulemaking authority in this situation. So as you're thinking about your rules today, you'll want to be mindful of the statutes that guide the rules. We're going to touch on the statutes that provide the guidance next, namely peer review and legend, drugs, and devices, but be aware that the statutes always need to be your constant guideposts in order to give the recommendations and your advice to the board and HLO about rulemaking. Okay, so first we're going to talk about peer review. ORS 687.480, so again, looking at that ORS, so we know it's a statute, talks about practice standards. And what that statute says, the legislature has told us, is that the board shall adopt practice standards that include participation in peer review. So participation in peer review is what the legislature has said, and participation in peer review is one of the rule topics that you will be working on today. So what else do the statutes tell us? So here we have that the peer review of a licensed direct entry midwife conducted under ORS 687.480 is subject to the provisions of another statute, ORS 41.675. So why is this important? So why this is important is because that peer review that is conducted under 687, which is a direct entry midwifery statute, it's subject to this other statute that is out there. That other statute that is out there, that ORS 41.675, sets out certain guidelines and protections that surround the peer review process and the peer review conducted under that process. So that's important to know, is that we have another statute that is providing guidance and providing guidelines and protections for these peer reviews. So for instance, a person who is serving on or communicating information to the peer review body cannot be examined regarding the communication or the finding of the peer review body. So that is one of the protections that's in this other statute, that other statute that we have to be aware of. And so that's one of the protections, is that the person who is serving on and communicating cannot be examined regarding that participation in that peer review process. So that's one of the things to be aware of. Another thing to be aware of in that other statute, that ORS 41 statute, is that it says that data is privileged. So when it tells us that data is privileged, what does that mean? Well, it sets forth that data has a very specific meaning. Data is all oral communications or written reports to a peer review body and all notes or records created by or at the direction of a peer review body, including the communications, reports, notes, or records created in the course of an investigation undertaken at the direction of a peer review body. So what that tells us is that data has a very specific meaning. We can't change that meaning in rule, but what we do have is that there's a guideline out there in another statute that tells us that data is privileged and tells us exactly what data means. So that's important to know. Also important to know is that data is not the charts and records that are created during or for the purpose of the practice of direct entry midwifery. So that's also an important piece to know. It's not the charts and records created for the purpose of the practice of direct entry midwifery. And that's actually in statute here. This slide goes over that. The charts and records created during or for the purpose of the practice of direct entry midwifery can be used as part of the peer review process, but using those charts and records does not make that information data. So it doesn't then create data, does not make the charts or records privileged. So that's an important piece. The statutes, we know that the charts and records created can be used, but then again, using those charts and records does not then make those records privileged. Hopefully that is clear. And this again is just further direction that we get from the statutes.
I want to clarify something about that, Heather.
Sure.
It means that if there was a separate investigation or lawsuit, that the charts would still be part of that investigation or lawsuit, but the records, like if I'm a reviewer and I review records and have someone else's records in my possession because of peer review, they are protected against discovery through me, through the peer review.
So I would think what we would want to do is look at that on a very specific basis. And so what I can do is say that when a midwife, a licensed midwife, is at a birth and documenting what is happening during that birth and creating those records for the purpose of direct entry midwifery practice, right? We have those records. So those perhaps something happens and they go through a peer review process. And so they bring those records into the peer review. Just by bringing those records into peer review does not make them data. Those records are direct entry midwifery records. Does that
I understand. I'm
Okay.
just saying, I don't want midwives on the thing to think that because they participate in peer review and have contact with someone else's records, that the records could be discoverable through the peer review. The records are discoverable because they're records. They're discoverable through an investigation process or through a lawsuit that goes directly to the midwife. They're not discoverable through the peer review body. That's not how it would happen. I'm not asking a question. I'm asserting I've talked to a number of lawyers about this and I'm privileged to a number of cases about this. I'm just saying peer review isn't the place that the records get discovered.
Thanks for sharing your experience with us. Appreciate that. Okay, so are there any other comments or questions at this point? Okay. So now that we have that information on what the statutes tell us in regards to what data is and how charts and records that are created for the practice of direct entry midwifery can be used, what else do the statutes tell us? So the statutes also tell us that peer review that is conducted outside of the health licensing office may not be used to replace the office's investigations of complaints against licensed direct entry midwifery. So again, just further information on what the statutes tell us about this. So an investigation is separate from the peer review process. All right, so just to summarize what we have from the statutes is that they tell us that the board shall adopt practice standards regarding participation in peer review. The charts and records created during or for the purpose of the practice of direct entry midwifery can be used as part of the peer review process. So that will be something to have a guidepost on as you're talking about your rule today. And that peer review that is conducted outside of HLO may not replace investigations of complaints. All right, so let's then turn to legend, drugs, and devices. Okay, so we have statutes on legend, drugs, and devices. The first one to note, an ORS, again, we know that's a statute 687.493, is that a direct entry midwife who's licensed under the statutes can purchase and administer authorized scheduled legend drugs and devices that are used in pregnancy, birth, postpartum care, newborn care, or resuscitation, and that are deemed integral to providing safe care to the public by the State Board of Direct Entry Midwifery by rule. So that provides us with the first direction that it has to be an authorized scheduled legend drug and devices, and then kind of sets up what those legend drugs and devices are and what their purposes of use are. So as we go further down in that same statute, it tells us that legend drugs authorized under that first part of the statute are limited to certain uses. And it sets forth the uses for neonatal use and also for maternal use. And so the statute provides us with that direction. They provide us with those bones for the uses for those legend drugs and devices. As we go down further, that went up, so let me make sure I'm going down. The third part of that same statute tells us that legend devices that are authorized in rule are limited to devices for injection of medications, for administration of intravenous fluids, for adult and infant resuscitation, and for rupturing the amniotic membranes. So it gives us further direction on the purposes for those legend drugs and devices. Again, these are just bones for you to work forward or to work with as you move forward with your rules. And so with a summary there, what we have from the statutes is that the legend drugs and devices are only those that are set forth in rule. So a licensed direct entry midwife can only use what is stated in the rule. that those legend drugs and devices must be deemed integral to providing safe care to the public, and that they must be for use in pregnancy, birth, postpartum care, and resuscitation. Further information is that legend drugs that meet all the criteria and are for maternal use are limited to the specific things that are stated in the statute, and legend devices that meet the criteria and for maternal use are limited as well by the statute. So the statute provides us with those purposes and with some direction there. So that's really helpful. So with all of that in mind, that is an overview of both the process for rulemaking, the process for the RAC, hopefully gives us all a working knowledge to be able to go forth with your RAC today. And so I wish you good luck in creating your bones of the dog and not of the cat. But I'm sure this was all exhausting. That was a lot of information, but wanted to thank you. And if there are any questions, then I would be happy to answer questions or take comments at this time. And then I will jump off so that Sammy can continue with your RAC meeting. Not seeing any hands raised. So thank you very much. Sammy, I will hop off unless you have anything that you wanted to have me comment on.
Nope, I'm ready.
All right. Thank you all. Bye.
Okay, everyone, I guess we'll just jump right in. Did everybody share my screen now? Yes. Okay, give me a sec. Here we go. So can you guys see my screen? Excellent. So did everyone get the materials? So the biggest, what I did is I gave you the current rule as it reads. Then a couple options. From what I understand, my understanding is that LDMs are unsure what an entity means. Does it currently, I think it says anything with over, is it 5? Yeah, more than entity through which peer review occurs must consist of 5 LDMs. I've heard that want that to be more specific, want that to have more guidelines around it, like it be a birthing center or an association like OMC. So some of the things, so we need to have a mechanism for accountability, right? Are we going to approve these organizations? Do we want to do that? It didn't sound like that's how the board wants to go. It wants to give them give you guys a framework, and then based on that, you go forward. So I don't think there would be an approval process, but so what we did based on that knowledge of wanting to have more more specificity around the entity, option 1 gives basically says who's, and then we also learned that, and anyone correct me if I'm wrong, because this gets a little confusing for someone who doesn't actually do it. The person who participates is different than the person attesting. So we've defined that in option 1. Tell you what peer review is. We didn't change that much. And then who's a participant. And then just putting some requirements around it and giving some actual examples in the rule, which I think is helpful, telling you what is an entity and what is not an entity. So that's my wrap up on that. If you guys want to just jump in and kind of start, we'll just go from option 1. Well, let me ask you this. Are we close in option 1? Or can it be pared down? So just go ahead and jump in anytime.
I think that there's significantly more work that's needed on this. This is Silke Akerson. And I think it's really important to step back a little bit and think about what peer review is for. And I think it's really important to understand that peer review is for quality assurance and quality improvement. It's a place where we can learn from birth experiences, improve our care, and also identify systems issues that affect care for way more than just our practice. And generally, you know, peer review isn't something that just happens in the midwifery community. It's something that happens for all healthcare providers and mental health care providers. And generally, people who attend births, like hospital-based providers, practice within this larger container of a hospital quality improvement program. And I believe, and OMC believes, that community birth providers need to practice within a larger quality improvement container as well. And that self-directed peer review in small practices of 1 to 8 people, which is the size of most practices in Oregon, isn't adequate for the kind of quality improvement that all community birth providers and the families we serve need. When we're in situations where we sometimes have people's lives in our hand, we believe we need peer review, especially sentinel event review, that connects us to current evidence and community standards, directs us towards continuing education when needed, and most importantly, works to identify systems issues in individual cases that, if we address as a larger community, could benefit way more birthing families than the one in the case being reviewed. And I think the current rule is really confusing, but I think that it's to me, an entity isn't ideally would not just be at least 5 LDMs. I think the point of an entity is that it's a peer review organization or a quality improvement organization, like what the Oregon Midwifery Council maintains and what I know that the Oregon Association of Birth Centers is in the process of developing, that maintains a charter and standards for peer review, and most importantly, can collect information from peer review that feeds back into quality improvement. We currently have a situation where there are midwives that don't participate in larger peer review, even though that is what's ostensibly required in the rule. And it means that there's feedback from births that doesn't come back to the whole system. And it means there's areas where we can't identify system-wide problems. Like, there's so many things we've done in quality improvement that were identified in peer review. Like, we've identified in peer review that there are major gaps in EMS training about newborn resuscitation, because we've reviewed many cases where there was a successful resuscitation in the home setting. The resuscitation was interrupted during the transfer, and then that had really significant impact on outcomes. If we don't see, if a body doesn't see enough peer reviews to see that something rare like that is a pattern, it can't know that that needs addressed. So my concern is, with the current rule and with both of the proposals, that there isn't something that's indicating that peer review needs to feed into a larger body that can work on creating solutions for the whole. Like, I can't tell you how many things, almost everything we do in our quality improvement program comes from being identified in peer review. So I would propose something that's much more specific, and I'll put in the chat what OMC proposes for peer review for that part of the rule. Wait a second, why can't I find the chat? And that's all I have to say.
Can you just email it to me and I'll bring it up on my screen? It's hard to track the chat.
Yeah, you said we're not supposed to use the chat. Okay.
Yeah. All this is new to everyone.
Yeah, I'll email it to you, and probably have more thoughts after other people speak as well.
Okay, great.
This is Hermine. I can't tell if my raised hand is showing. It doesn't, so I can't see it on my image, but my hand is up.
Hermine, I was just not paying attention. I'm sorry.
Oh, no problem. Could I contribute a little bit, Sammy?
Yes, absolutely.
Okay, thank you. So my name is Hermine Hayes Klein. I'm an attorney, and I'm here representing the Oregon Association of Birth Centers. So, I mean, I think that, as Silka says, pulling back the lens a little bit is important before we get into the details. And so, again, pulling back to the lens that Heather was guiding us through regarding what should we bear in mind about the law as we head into this process, a very important point that I think she touched on is that the law should not contradict itself. Rules should not contradict other rules. Rules should not contradict statutes. Statutes should not contradict statutes. So an important function of the RAC is to, and of course any bodies that are involved in lawmaking, is to consider these rules in light of other rules and look out for potential conflicts. So from that perspective, and in addition, an important aspect of the law is that the law should not be discriminatory. So if the law treats two similar types of groups very differently, there needs to be an explanation for that is rational and non-discriminatory. So from that perspective, OABC is concerned about conflicts in these peer review rules and statutes governing peer review for different license types. And the fact that the conflict, namely the other statutes, like for the medical doctors and the naturopathic doctors, do not mandate peer review for all of that license type. There's no mandatory peer review for all doctors or all naturopaths. And so that conflict is difficult to understand for any reason other than discrimination against the license type of direct entry midwives. So first of all, I think we would like to hear from anybody at the state that can explain the basis for this difference in treatment, to explain why, how can the state justify imposing mandatory peer review on this license type when the same license type that provides the same services of labor and delivery postpartum is not subject to this. And so we can go, again, so there's no mandatory peer review for the MDs under OAR 847-010-0095. There's no mandatory peer review for naturopaths under OAR 850-005-0185. So why is it mandatory for the LDMs under this rule? That itself is a conflict. And then for birth centers in particular, an even more problematic contradiction, although the other one is problematic, is that this rule contradicts a statute, ORS 441055, which sets the standard for peer reviews for healthcare facilities. Freestanding birth centers are recognized as healthcare facilities under ORS 441020, ORS 441098, and OAR 333-076-0450, among others, which define birth centers as any healthcare facility licensed for the primary purpose of performing low-risk deliveries. Primary purpose, that is, not exclusive purpose. So again, there's concern that the statute that sets peer review for healthcare facilities makes clear that the facility itself, so in this case, that would be the birth center, gets to decide when peer review is appropriate. The state isn't mandating peer review on the facility or its providers. The facility gets to decide. And the facility also gets to decide.
Immediately. Thank you.
No problem. Okay.
Oh.
And the facility also gets to decide when they want to bring in anybody from outside that facility to participate in the peer review. The statute also makes clear that any report that comes out of that facility-based peer review is for the benefit of the facility itself, so that the facility can make an informed decision about whether and how to discipline the provider or make practice changes to serve the safety of patients. This is what Silka's talking about when she says the purpose of peer review is feedback for quality improvement. These rules that affect the LDMs look more like police state oversight of LDMs because we don't trust that license type. And that looks discriminatory because indeed peer review is not the only method or mechanism by which midwives could communicate about how they practice or for the purposes of practice improvement. So therefore, the LDM rules represent a major departure from that statute that would presumably impose a completely different type of peer review requirement on Oregon healthcare facilities if and only if they employ the licensed type of direct entry midwife. So I think the first thing that we would like to see discussed here by anybody who has information about this is how are these contradictions justified and how can they be resolved in a way that's non-discriminatory?
I think I can answer most of those questions.
Thank
Just
you,
for
Sandy.
starters, I don't know the statutes for doctors or for birthing centers. I would have
They're
to go
attached to
and
this.
consult
They
those.
are part of the materials for today's meeting. They're
Correct.
pages 24 through 27 of the meeting materials.
But I don't know how they carry them out, what requirements they have in rule. What I do know And I think you're right, is all that the law for midwives requires is that peer review of a licensed registered midwife conducted under 687-480 is subject to the revisions of the law that we know about, and charts, records. So that's it. It doesn't say we have to create a rule about it. That's a choice that the midwife board has made over, as far as I know, I've been here 26 years, that it's always been there. And it's had different versions. And so this has been I don't know, I don't think it was ever a HLO or all of our many forms rule that we mandated. But it's definitely something that we can talk about. I mean, you could get rid of it.
Yeah,
I
thank you
think
for that,
the law
Sammy.
may allow that.
I mean, that clarification that it's coming from the board, therefore, makes me want to, we're the advisory committee, right? So we're here for the purpose of sharing our perspective with the board. And so, therefore, a perspective that I would like to deliver to the board, and I don't know, the extent to which they're present in this call or will review the recording, is why are you treating the license type that you represent so differently than the state treats the other license types in a way that imposes a more costly and onerous requirement on them than is imposed on the other providers of the same services? Why are you writing a discriminatory law for your own license type?
And just to jump on there, 687-480 does require that the board adopt rules for the administration of participation and peer review. That's pretty vague.
Right. They could write in a way that
rule.
doesn't contradict the other statutes. And that's what I would ask them to do, is to review the other statutes that are attached to this and look at to what extent are they making this more mandatory on LDMs than it is on obstetricians or on naturopathic doctors.
Okay, and
Silka,
just to finish my statement.
Oh, sorry, Sammy.
We do already have a rule in renewal that says you must participate. So that, I believe, that would meet the requirement of this law that says we must have rules for participation in peer review. The renewal rule, I believe, meets that requirement. So that's all I wanted to.
What rule is that, Sammy?
The renewal rule is, hold on. It is 332-020-0000.
Okay.
And number 2 is license renewal. And it says attest to participating in peer review pursuant to the rule that we're looking at today. So
but just to close the loop, it's just coupled with this and assuming this rule that mandates peer review for LDMs. But what I'm challenging is both of those. I'm challenging the idea that the board has created rules for midwives that contradict statutes and look discriminatory.
All I'm saying is I think that rule meets, just that rule alone meets the requirement of law.
I would say it doesn't, because if that renewal rule assumes that LDMs must do 2 peer reviews in a way that no other rule, okay.
All it does is say they must participate. So if you just had that and you deleted the peer review rule,
got it.
It is just that.
Thank you.
Participate.
So I think this is a really interesting conversation, and I'm really glad you brought it up, Hermine, even though I approach it pretty differently. I think there is a major inequity here, but I think the inequity is that, from my perspective, is that it's a problem that peer review isn't required for all delivering providers. I think that is actually a huge quality improvement oversight, that there isn't a requirement for delivering MDs, delivering NDs, and delivering CNMs, and I identify that as the problem instead. Most of those providers are required to peer review, but not by statute or rule. They're required because they're delivering hospital providers, and they're required by their hospital, through their contract and their employment. But I think, to me, that us losing a requirement to peer review would be like a phenomenal safety travesty for me, not because LDMs are less trustworthy or less competent than any other provider type that attends births, but because I think that peer review is the absolute and essential backbone to quality improvement. And we have issues even with our requirements with people participating. We definitely have people who are not in compliance. And I think I think every single delivering provider needs to attend peer review. So I think that it is inequitable. Absolutely, it is inequitable. And I think there are lots of other times when the LDM rules have over requirement, like the amount of prescription about consultation or transfer criteria is excessive and discriminatory in comparison to other providers. But this is one area where instead of us coming in line with other boards, I'd like to see other boards come in line with us.
But until we do, we have a unique requirement imposed on the provider type with the least amount of money. You know what I mean? And later we'll talk about fiscal impact, but of course there's an impact of having to cut out of your work to go participate in these peer reviews. And while I can see a value to these things, the question is whether we need the state to mandate it. So for example, we know that LDMs should have practice standards, right? And there should be a list of risk factors that drive, your transfer. But does the state need to list them out in the rules? Of course, that's not at stake in this RAC, right? But it's an example that we can point to. It's not like the law is the only mechanism that could possibly make midwives do the right thing. And that's what looks discriminatory, is the idea that other provider types can be trusted. Hospitals can be trusted to create internal peer review processes, but that for LDMs, we don't trust them. You know what I mean? So while I think you're right, it would be great if there was cross-license type peer review. That's what core SILCA, what we need is collaborative, integrated peer reviews where we're really, or for lack of a better word, right, a processing of births, what could have been improved. We would see quality go way up in the state if we had that. But the question is, what's the role of the law in that? And, is it fair to mandate this on the poorest license type, you know what I mean, and wait for the richer ones to catch up later when they choose to do so?
I guess I think it is. I think it's so essential. I think to me, in some ways, it's the most essential thing that we do as providers who attend births, is to do this check and balance of reflecting on our care and looking at where we can improve. And I think that it is a basic cost of being in practice.
I think other folks might contribute to this.
This is Willa. I don't know who was next with their hand raised, but I had my hand raised. I just want to say, the one of the issues that I think is important to mention is that, so myself as a birth center owner, employing other licensed midwives, myself being a licensed midwife, I guess as a general comment, is that it just frustrates the fire out of me that the board would not assume that we were, after licensing us to be midwives, that we weren't intelligent enough to continue peer review, which of course we all are, but then not be able to choose with whom we think that peer review is the most effective. I think my thoughts on the peer review is that I do think peer review is essential, but I think we're all going to do it whether it's in our law or not. And as part of a very busy birth center, we're constantly doing the quality improvement. But to us, it is, as a birth center owner, as a birth center team, peer review is the most effective when we can call those specific people that we need at each peer review to learn the most out of what we can. Not specific, some of those are going to be our peer LDMs, but in our practice, most of the time it's also MFM, attending OBs, the pediatricians that we've referred to, and having all of them, which is very frequent for our birth center. But assuming that we aren't intelligent enough to pick those team members that we feel most useful for our own quality improvement and training of our staff, it just drives me nuts. I just had to say it, sorry.
Nora,
Sammy, I
you wanna
don't know
go
if you're
ahead?
seeing the hands up, but
Yeah,
Nora.
Nora next. I am. And
Hi,
I don't
thanks.
know if Hermine, you want to talk again, Silke, you want to talk again, because your hands are still up. So Nora, then
It's down.
Silke. Perfect.
I just want to appreciate this discussion. I think it is incredibly important, of course, that we do peer review. And I also find it extremely discriminatory. And it's one of several things in our statutes and rules that I find very different than other providers that are providing the similar care that we're doing, and they're not required or limited in the ways we are. Really quickly, as to the options, I would suggest number 2 over number 1. but I'm not satisfied with number 2 either. Generally, I feel like less jargon and run on is better than a lot of what feels like limiting scope. And it is extremely difficult in a rural place to do this. And the only reason I have been able to do it is because of the pandemic and doing online Zoom peer reviews. I'm on call. There's no way I can drive where there's 5 other providers. And OMC has allowed me to kind of piggyback onto the Portland area folks, but I am 6 hours away in an entirely different rural situation with very different clients, and it's really not as relevant often, and that's clear. So I agree with a lot of what Hermine is saying. If we could drop the rule that adds this extra stuff that is not legal or, in my opinion, ethical to what other providers are doing, that seems a lot better to me. Thank you.
Silka and then Hermine again.
I think these, geographical difficulties are really important to address. And I don't know if you saw, Nora, but we're implementing an online statewide OMC peer review moving forward. That's going to happen at least twice a year to have better reach for a lot of people. I think it's interesting to have this conversation with the people who are here, because the people practicing midwives who are here, Nora, Willa, myself, and Lennon, really consistently show up to peer review. We are super engaged in peer review. We are going to do peer review no matter what anyone says. But something that I want to tell you as the director of the statewide organization of which, for LDMs, is that it's not consistent across the state. It's not consistent that people participate in peer review. There are people who really strongly believe that their care is only between themselves and their clients, and that they should not have to interact with other people about it. There are people who peer review in only a storytelling manner with friends and are really avoidant of getting any direct feedback about their care. There's a whole strong range of things, and there are also birth centers who have developed very strong cultures of care, and when they peer review only internally, which some of them do, it's very difficult to get any feedback or fresh perspective about whether the way that they're practicing serves clients the best. And I think that we need some requirement where people have to do peer review with groups larger than their practice sometimes. There's nothing in the rule that keeps us from reviewing with CNMs, with NDs, with MFM, with OBs. It just says that we also need to include other LDMs. And I genuinely think that requirements are needed. This is the area of our rule that midwives are the most out of compliance with the rule, including before there was a rule about an entity, because we don't all voluntarily engage in the uncomfortable process of being seen in our care and stretching to grow around our care. And I think that would be very important for any other provider type that attends births that isn't required to stretch and grow in this way to have that requirement also.
Hermine, and then Lennon.
I thought I'll let Lennon go first because they have not contributed yet, and then maybe if Lennon doesn't cover my issues, I'll add again.
Great, thank you.
Hi, this is Lennon Clark, and I just wanted to make a quick input about some of the stuff that's been talked about. I know another issue that is, has Silka mentioned how some midwives are actually just not going to peer review. That definitely is a real thing. But what I've seen in my region is that there's to some degree a distrust of the, I guess I'll call it the entity peer review because of issues in the past. And I think that you know, those midwives that don't feel safe necessarily sharing at that peer review, they're still showing up because they have to, or they're supposed to, you know, because of the license renewal that they have to attend an entity peer review, but they're not necessarily peer reviewing there. They're still peer reviewing with their, you know, not necessarily their practice, like outside of their practice, they're gathering other midwives that they feel like it is a more safe space to peer review. And so I think that there's also midwives that do believe in peer review and want to attend it and really do want to have that feedback, but also feel, you know, also very protective of, you know, peer review can be a very vulnerable time. And so I know that for some people, the entity requirement is difficult in that sense. And so I just wanted to say that.
This is Hermine again. So, I mean, it seems to me that we need different rules for birth centers, which are healthcare facilities, and for home birth midwives. I mean, I think what Silka's pointing to is that home birth midwives don't necessarily operate within a group that would naturally, you know, with whom they would naturally confer about cases the way that you know, folks will within a healthcare facility. But I mean, I think for birth centers, you know, Silka, you spoke to culture of care. That's true in hospitals too. We know we have plenty of studies that show that, for example, C-section rates are a product of culture of care at hospitals. And yet hospitals are allowed to handle their own peer reviews internally. And there's nobody coming in to say, you know, let's look at how your obstetricians are doing this next to the others. And yes, it would be great if you know, maybe there's a space for that in the future, but a state agency like the board or the HLO has the capacity to roll out peer review rules for all these folks that are non-discriminatory at once. So if the state is interested in facilitating the kinds of communications that we all agree are valuable, then the state could mandate integrated peer reviews. You know, for example, a peer review after every transfer, which is something that I always advise midwives to try to set up informally with hospitals, especially emergent transfers, set up a sit down. But as you know, many hospitals won't come to the table for those. And so that leaves that as a broken opportunity. So, I mean, the fact that hospitals have that there's cultures of care within birth centers is not a reason for that to treat them differently than all other healthcare facilities. And asking a health facility that is a birth center to have a separate process for peer reviews for this one license type looks very much like discrimination. And so that's problematic in itself. I would recommend that the board has rules for birth centers that match the rules for hospitals that are described under you know, OAR 847-010-0095 and the associated statutes. And then for home birth midwives, you could essentially replace all of this specifically micromanaged process with a form that explains for each individual midwife how she does peer review, who is she doing it with, how often a year is she doing it. So I mean, so it could be, if you want to know, do they do it, who are the midwives in their community that they work with, a form could accomplish that goal. And then as far as quality assurance, I mean, again, there's this like fundamental philosophical question of, is the only way to achieve quality assurance to micromanage on the front end? I would say no, there's back end quality assurance, and actually that's what the board exists for. So if there was a birth center or if there was a home birth practice that is going rogue, you know, as has been suggested on this call, that there are home birth midwives out there running rogue, doing whatever they want. Well, we have all kinds of standards in this state, you know, even outside of the micromanaged rules. Other states that don't micromanage their CPMs are able to review, investigate, manage complaints regarding quality of care without having to do that front end micromanagement. So again, the fact that there might be midwives in this state that are, you know, practicing subordinate to the level that we would all like to see, as we know happens in all settings, doesn't mean that we have to have this front end regulatory micromanagement. We have quality assurance systems for the back end. If that midwife is running rogue, doing dangerous births, she will face complaints. If she's not facing complaints, maybe she's not actually doing such a bad job. So, you know, if she's running rogue, if she's doing a bad job, there should be complaints. And if the board's doing its job, it should be able to handle that on that side without the necessity of this kind of micromanagement, quality assurance on the front side for all midwives.
Looks like Heather, and then Silka, Lennon, Hermine.
Lennon
Yes,
had her
Amy.
hand up before me.
I just
Oh.
wanted to remind the RAC to look to its statutes and the statutes that the board has jurisdiction over and that the RAC should be working within are the DEM statutes, the direct entry midwifery statutes, and that other statutes governing other boards are just different statutes, and that what this RAC needs to be doing is looking at the DEM statutes and not looking at and going into jurisdictional issues.
That's not
across
true,
into other
Heather, because
boards.
healthcare facilities, I don't know if you were off the call when I spoke to this, when I first spoke, the law cannot, statutes can't contradict other statutes, rules can't contradict statutes. So the DEM rule can't contradict other applicable statutes. I understand that the DEM statutes apply, but there are other statutes that apply to, for example, freestanding birth centers. So freestanding birth centers have statutes that are contradicted by these rules, and we do have to attend to that fact and figure out how to address the contradiction. I'd be happy to tell you specifically, if you missed it earlier, what statute is being contradicted by these rules and why it's relevant.
Yeah, why don't you go ahead and repeat that? That'd be great.
Okay, yes. So there is the statute ORS 441055 sets the standard for peer reviews for healthcare facilities. It doesn't carve out birth centers from that statute. That statute that sets peer review for healthcare facilities makes clear the facility gets to decide when peer review is appropriate. The facility gets to decide when they want to bring in anybody from outside the facility to participate in a review. And the statute also makes clear that any report from that peer review is for the benefit of the facility itself, so that it can make an informed decision about whether and how to discipline the providers. Freestanding birth centers are healthcare facilities as referenced by ORS 441020, 441098, OAR 333, 076, 0450. They are healthcare facilities. And so therefore, the problem here is that these rules would mandate a very different form of peer review for one license type within healthcare facilities compared to other license types providing the exact same services. And that looks a lot like discrimination as well as conflict. We've got this statute that says what healthcare facilities must do for peer review. And then we've got this other rule coming out of left field to say that, oh, but there's a different rule for this one license provider type. And that to me looks like a discriminatory problem that I don't think we can ignore in this RAC.
Thanks, Hermine. And I'll just remind the board to be operating within the direct entry midwifery statutes. There are a lot of providers that work in hospitals, and all of those providers are governed by different rules and different statutes that pertain to nurses, respiratory therapists, all the different types of people that function in hospitals. So I appreciate the feedback so that the board has that and can look into that issue. But I would remind the board to stick to the direct entry midwifery statutes and the authority under their statutes.
Lennon, did you lower your hand? Because Silka, if so, Silka and then Sarah. Sarah joined us about 10:30 for the record.
Yes, sorry. Yeah, I didn't realize I had to lower it. So sorry.
Oh, no problem.
All right, thank you. So there's such rich conversation going on here, and I want to make sure to respond to a number of things that have been talked about. One thing that has been mentioned by a couple of people is the idea of tracking who LDMs do peer review with, or disclosing who LDMs do peer review with. And that's something that OMC has always objected to and will continue to object to. We don't think that the board should be collecting or requesting data about who midwives attend peer review with. That is confidential. And like who specifically? The other thing that I wanted to say is that it's actually extremely common for other states to have specific requirements around peer review, and it's something that's becoming a standard. One of the states that's acknowledged as the most kind of like gold standard for midwifery rules and regulations is Washington State. And while they don't have the kind of level of detailed or prescriptive rules that we do in Oregon for practice standards, they do have detailed and prescriptive rules for peer review, and they require peer review with a peer review organization for the purpose of quality improvement. I strongly disagree that requiring peer review is micromanagement, and I think it's extremely important that there be a requirement. It is the absolute most basic thing that we need to do as people who attend births, and the complaint process is a completely different entity and cannot do the things that peer review can do. Peer review is about prevention of poor outcomes and learning and supporting providers so that they can practice to the best of their ability. Whereas the investigation and complaint process, when it is either has no outcome or generally punitive outcomes, it does not have a quality improvement function. It has a regulation function. Those are very different. And it's extremely important that things be built in on the front end that support optimal practice. I was really glad that Lennon brought up how people can feel uncomfortable in entity peer review. And it's one of the reasons why I think it's really important that it not be like the requirement in Washington State, which is specific to a particular entity, but instead be a requirement that is about participating in peer review with a peer review organization or quality improvement entity, so that there can be more than one entity and people can participate where they feel is appropriate. I also think it's important that people understand that participating in the current rule, participating in peer review with an entity doesn't mean you have to review any case that you need to review with an entity in a large group of people who aren't of your choosing just at the regular peer review. You know, as a rule, the Sentinel event reviews happen with a very small select group of people, and the person being reviewed has autonomy about deciding, you know, being part of choosing who that review happens with. And it's of great concern to OMC that there is a region where someone violated the kind of agreements of the peer review in a way that makes the peer review feel unsafe for other people. And we've been trying to work with that region where you are, Lennon, for a long time to figure out how to change the peer review there to make sure that people feel safe to review in that setting, and also to provide alternates, smaller reviews, so that people don't feel forced to review with someone who violated the agreements of the peer review.
Sarah?
Hi, this is Sarah Dinger. I'm a practicing midwife in Portland. I missed part of the start of this conversation, but I was feeling very troubled by one specific thing, which is the use of the terms front end and back end as far as ideas for addressing quality control and quality improvement. And I mean, that actually just feels like a euphemism for me. Like the back end is like when something bad has happened. That's like after a loss, you know, like I really strongly disagree that back end quality improvement, or, you know, as Silke is saying, it's not really as much quality improvement when it happens on the back end. But that means if we're putting our quality improvement on the back end, that means we're accepting that these losses are happening before we make improvements. And I think it's really important that quality improvement happens on the front end to prevent poor outcomes and losses, and to encourage learning before, hopefully, you know, ideally before those things happen. And of course we need both things. And you know, like I feel conflicted because I think peer review is so important, and I also want fewer regulations, and I want fewer regulations that are specific to direct entry midwives. But if people aren't going to peer review without a requirement, then I want there to be a requirement because I think it's so important.
I didn't see who, Nora, then Hermine. I don't know who was on first.
Nora's first.
I just want to appreciate a few things about the continued importance of this and kind of hoping that it is, I don't know how then when the board reviews it, if they listen to the whole recording. But just once again, to kind of say that it does feel, I appreciated the word that Hermine used, even though it's a strong word. It does feel like micromanaging. And that is, I absolutely want to participate and do and go out of my way to participate. But it does feel like having a whole separate entity is one more way to kind of nitpick how something is done when those of us that are already doing it are already doing it. And it's a little bit like we're being punished for those that are not doing it. And I don't know that adding that clause is going to change the behavior of people that are already not doing it. But it does make it more difficult and more discriminatory for those of us that are. So that's my latest thought. Thanks.
And I guess I would bring this question to the LDMs who feel that this kind of peer review law is the only way to ensure safe care by LDMs is why you have so little distrust for your fellow license type. They have been trained as you have. They have been licensed as you have. Where does the belief come from that without this kind of mandate, something bad's going to happen? You know, and again, and you know, you do your CMEs, like there are many mechanisms in place to ensure that this licensed provider type is competent. And I just find curious the suggestion that these additional laws that don't exist for other provider types are necessary for LDMs to ensure that they give safe care. And you know, I think Silka's point was well taken about naming individual participants in peer review. And so I think that, you know, I think OMC can continue to offer peer review. And I think an OABC, as Silka mentioned, is going to offer it as well. As everybody agrees, peer review is critical. These conversations need to happen. The question is, should it be mandated or should it be available? And so I mean, a form could say, are you going to do your peer review with OMC or OABC, for example? It wouldn't have to name individuals that you're doing it with. And we could talk creatively on this call, because what you guys are trying to get at is those midwives running rogue. Like what we're talking about here is the idea that there are some midwives out there running rogue, doing dangerous care, and that only with these kinds of mandates can we keep the public safe from those midwives. And so presumably those are home birth midwives. They can't be birth center midwives because the birth center has so many laws that govern the quality of care within that space. So therefore, I'm going to bring back the question, why would we have any mandate like this on the healthcare facility of the birth center just for LDMs? And then again, like to those of you who are LDMs advocating for this as a mandate, why, given all of the other quality assurance that exists from your training to your continuing education, to the fact that the board does review bad outcomes or questionable outcomes when they occur?
I'm going to jump in. I could even put my hand up. So there is a form that we have, and I pulled it up on my screen, that is available to midwives to use. And in the event that they were audited for their renewal, they would just submit this form. It's pretty vague. Who's the entity? Who's the peer reviewers? Pretty vague stuff, not who, you know, you're actually reviewing and all, like clients and things like that. So that does exist. In 2019, the old rule was pretty simple. And in 2019, the board changed it. It was just pursuant to 687-480, the licensees, here, I'm going to pull it up. I'm going to share it. Stop sharing. Because maybe this will get you there.
Tammy, it was shared. Now you took it down.
I know.
Oh.
No. Okay, so that's what it was before. So it's pretty vague. I mean, it just said you must do it, and then there were a few conditions. You have to do it once a year, and then twice a year if If the licensee served as a primary midwife attendant and more than 40, it'd do it twice a year. So this was the previous rule in 2019. The board specifically took a closer look at this rule and made it bigger. So I just wanted to add that. And then the third thing is, I think that this conversation is important. Just wanted to note that if we can't get a consensus, which is possible, often happens, we can make 2 recommendations to the board. So that's just food for thought. I will now part ways, and Silka and then Nora again.
I want to do some reframing. Hermine, those are your words about not trusting LDMs. That's not my experience. I'm someone calling for this, and it's not because I don't trust LDMs. Like my entire life is devoted to LDMs and other kinds of midwives because I trust them, because I love them, because I think the care that they provide is excellent. And I think we all need a minimum support. If we're people who are receiving babies into the world, we all need the minimum support of being part of a quality improvement program. And I think peer review is the backbone of that for midwives. And because of the way midwifery is structured, and because of how busy midwives are and how, consuming this work can be, some people without the container of a requirement around peer review don't participate. And that's largely because we have such small practices. There are people practicing on their own completely, or just with one other person, or in a small birth center with, 3 midwives. And that is a lot to do the whole function of quality improvement on your own in a practice that size. I would argue it's actually a lot even for the largest birth centers in Oregon. Quality improvement involves looking at the whole, the outcomes for the whole, the information coming in from the whole, and identifying what's happening in the system, what's not happening in the system, what supports do midwives need that they're not getting, and then having entities, not one entity, but entities looking at that all together and figuring out how to support these midwives in doing their best. And what I'm simply saying is that without that container of the rule, we lose some people. We don't lose them because they're bad or terrible people. We lose them because their job is all consuming and they're practicing on their own in, places and ways and times that that's not their primary focus. And I don't know that we need to go back and forth discussing it more. I think we'll probably need to come up with 2 proposals because we're really clear as a quality improvement organization that if we, for me, if we had one rule, it would be this. If we got rid of, beyond what our requirements are for licensure, it would be requirements for licensure, requirement for continuing education, and requirement for peer review. End of story.
Nora?
It's sounding like giving a couple of suggestions is what we need to do. Thank you for bringing up the 2019 rules. It was helpful to see that because it was my memory that it seems to be expanding and getting more demanding and more oversight over the last few years. I don't know where that driving is coming from, but it is palpable out here. And I just want to caution against too much constriction excluding people in the future from wanting to be LDMs or wanting to continue to be LDMs. I do absolutely understand the importance of it. I feel like there is rules in place and there's still the point that those rules are discriminatory. So that has to be addressed. But to me, it seems like there's already good rules in place and they are getting more stringent. And that doesn't feel good. So caution against more stringent so quickly every few years, ramping up the demands and the oversight of it doesn't feel fair. So thank you.
And if memory serves, the decision to expand this peer review rule was based on how Washington has a quality improvement program and trying to not become the same, but trying to move in that direction. So that was That was the catalyst for doing that. Okay, Willa and then Silka. No, yeah, Willa, then Silka, and I'm not talking anymore. Okay.
Nora, I just want to say thank you so much for contributing and being so honest today and saying things that some of us don't always often say out loud at these meetings. You know, I agree with a huge portion of what everyone here has said today. I'm sure we probably all do. There's bits and pieces of we feel that resonate with us from what everyone has said. I just want to kind of second what Nora has said. You know, we're kind of here meeting on, and like, you know, Silke, you said yourself too, most of us here are you know, constant contributors to peer review. It is the outliers, those that I guess have gone rogue, that aren't, we use that in a very different way at our practice, but those that aren't doing peer review around the state. But more regulations is not going to cause those outlier rogue people to do more peer review. More restrictions on those of us that already do. I guess it's not more restrictions, it's clearing away the gray area. And that gray area is there so that we each have more choices as to where we peer review and how we peer review and with whom we peer review. But by reeling those in constantly, I think, Nora, you're right. You hit it right on the head. And you know, Hermine, you said it too. We're limiting the availability of those of us that are super busy or live way out, 100 miles from anybody else or whatever else. We're limiting the availability and the friendliness, I guess, of peer review when we just keep piling on restrictions and limitations and more rules when we're all already trying so hard to do what our licensing body is telling us, not only because the licensing body tells us that, but because we all want to be safe midwives, and we do these things. So I agree, Nora, we just have to be careful with how many restrictions we write down in the black and white, because then it does tend to cause more people to go even more rogue. It's not going to save the ones that aren't willing to participate already.
Okay.
I just wanted to clarify that I haven't heard anyone propose more restrictions. There was one change in the peer review rule that was made in 2019, and both the proposals that are on the board on the table today, one of them takes away some of that requirement, and the other one just clarifies what an entity is, because people have been really confused about what an entity is. I'm not proposing more restriction than what's currently in there, and I haven't heard anyone propose that. And it hasn't been stepwise where it's been restricted multiple times. There was one change in 2019, and there's a desire either to step down somewhat from that 2019 change or clarify what an entity means, because people have been really confused about the wording. It's my understanding.
I appreciate that, Silka. And yet I would also put out there that just because this draft of the rule is not the moment when the mandate was invented, it was presumably invented years ago in earlier drafts of the rule. The fact that we're revisiting it does give us the opportunity to revisit whether the mandate should be kept at all. We're revisiting how this rule should be changed. The draft we've seen is one proposal, but that it could be edited, and the edits could include the removal of the mandate. So, this is our best chance to talk about that. There won't be a better chance than here in the RAC. Like, why do we have this mandate? And I guess what I'm looking for is, like, again, from the board, either please remove the mandate because it's discriminatory, or give us a good explanation for it. Why LDMs in a way that is different from all of the license types? Why should they have this mandate and nobody else?
I'm not the board, but I can only give you feedback as to why the original rules and the 2019 rules, I went back to 2000. They were like that in 2000. So many, many years were they that very vague rule. And the new one that was done in 2019, the new one with additional entity, and that's really what was added, is the entity piece, was just to make it more legitimate. I don't know that they actually offered a sound reason as to why, other than we've always had one, and trying to align it with Washington and making it more legitimate. They wanted to do that in 2019. I'm sure somebody else has a better answer than I do, but
Yeah,
I do.
like-
And I think that when we look at original rules that were discriminatory from the start, we're looking at the fact that the birth of midwifery in the state of Oregon, like elsewhere, came out of a status quo of discrimination against midwifery. So there was already the idea that this is a suspicious provider type that needs a higher level of oversight, and that baseline discrimination was not adequately challenged at the start of the drafting of the rules. And so we have this vestigial discriminatory law that we're looking at refining now, when really we need to look back to why do we have a different mandate for peer review for this license type than everybody else. Hopefully the board has evolved to the point that it can actually ask that question.
I think that's a good point. I mean, the law itself has seen many revisions, right? So, and now today, the law is pretty clear that the board has all the authority. But prior to that, it wasn't that case. So I think it's relevant that you're looking at this and looking at it from a bigger perspective. And maybe you're right. Maybe it's, I don't know that the board ever thought they're trying to, well, I guess, be discriminant, but I don't think the current board feels that way, or but maybe before that, I don't know. So
they might not have been aware, but now this is us bringing it to their attention that if you really look at the different provider types of the same services, it's a very different mandate.
Right, and they're aware of that. So I do know that. I think it was Nora and then Sarah. Nora, you're on mute. Sorry.
Sorry, no, thank you. Sammy, are you able to scroll down? Because I was thinking the changes included from once a year to twice a year, the introduction of an entity. And did it used to be 3 and now it's 5, or is that with the introduction of the entity?
So here's the current one.
Nora,
So-
you're correct, except for the part about the 3 to 5. There wasn't
Okay.
a number requirement before.
Yes.
Because twice a year is also a significant increase, which is fine for those of us that are doing it and doing it informally way more than that. It feels like changes more than one.
And also the requirement is only once a year for with the entity.
Yeah, you have to do 2, but 1 has to be with the entity.
Right, and it used to be 1 if you attended less than 40 births.
Right.
Which is many midwives. And then it's
And I
changed.
can tell you about the board intention about that. The board intention about that was an idea that if someone is intending fewer births, that would actually be a desire for more peer review in that situation.
Sure. No, it makes sense. And I totally support it being 2. I think it's just the inclusion of half a page of it. It becomes not more clarifying, but more confusing, because you could look at that and then say, oh, for example, it's 10. And then it's suddenly like what goes on with HERC, where then it becomes written into it that it is 10. And so to me, less is better. We're doing it already, those of us that are going to do it. Less words is better, not less peer review, to clarify.
Sarah?
It's a little bit, I think this conversation is extremely confusing because there are 2 conversations happening, and one is about the entity and one is about getting rid of the requirement completely, and both conversations are happening concurrently. But I did want to respond to Hermine's question, which was why LDMs, and I think that one possible answer to that, and this is coming from someone who is like deeply offended and opposed to discriminatory rules according to provider type, but I think one possible answer to that question of why this requirement for LDMs is that maybe LDMs are striving for excellence in a way that I don't always see reflected in other provider types, and that's something I want to keep. I think it's amazing.
I'm gonna just go down the list and see if anybody who hasn't spoken wants to. Jean's not on, Lennon, Willa. Donisha, do you want to weigh in here at all, or you just want to keep listening? I don't want to call you out, but I just want to make sure you have a chance if you want to talk. I'm gonna take that as a no. She's not going to talk. So I don't know if we're at a place where you want to talk about the two different recommendations. Do any of you feel like going back to the 2019 is sufficient? Do you want to get rid of it altogether? I'll show you, I believe, Silk, I want to make sure I drafted it correctly. This is the OMC option. So it leaves everything, if I'm wrong, Silk, if I did this wrong. And then 4 changes to add a midwifery peer organization or midwifery quality improvement program that maintains a charter and standards for peer review and consists of more than 5 LDMs, and then remove one of which must be, and then that would be it, correct, Silka? And everything else stays status quo.
Yeah, that's our proposal.
So I guess 3 things, 5
And
things.
that entity is again just for once a year.
Right. Do you want to delete it altogether? And or go back to 2019 and or change 2019, like mess with it. Do the OMC or some version of the OMC's option. And it sounded like option 2 of the 2 options that HLO presented would be the better of the 2. So I'd like to hear some discussion on that. On those 4 things. What direction do we want to go in?
Could anybody explain just who drafted these and just give us a little background on the thoughts behind? I mean, Silka, it sounds like you might have been involved. Are you guys able to just illuminate, just summarize the difference in your perception between these 2 options, and you know, have there been parties advocating for each of these, and why?
With the options that Sammy's sharing, we were not involved in drafting those. The only thing that OMC has been involved in drafting is the option that Sammy just put up, which was OMC's language. And after the conversation, do you have that still up, Sammy?
Which one?
The one that I sent you?
Yes.
Will you scroll down to the bottom of it? Oh, not quite that far, sorry. The bottom of the part that I said.
There.
I think that it, I would be comfortable taking out the consists of more than 5 LDMs part, like just the part of a midwifery peer review organization or midwifery quality improvement organization. Because I'm hearing, like, I get the idea that there's can be too much prescription and too much detail. There's a lot of things that can happen under the umbrella of an organization. I think people might not realize that a lot of really small reviews happen under the umbrella of OMC and would happen under the umbrella of any other organization. Like a person could still, Nora, you could review with Juniper, and if it was in agreement with OMC, that, you know, could be an OMC peer review. It doesn't mean there has to be someone like looking over your shoulder. It's like it happens within under these auspices, and it happens in the form that that organization describes.
But 2 of us would not be enough under any rule, right?
Yeah. Yeah, I was just making an example. Like you might have someone else on Zoom, or because there's just 2 of you out there, but you know what I mean? Like, I think sometimes when you see like something is conducted through an entity, people are imagining that means the regional OMC peer review meeting. And what I want to say is there are peer reviews conducted through OMC as one of the entities that happen in all sorts of different forms, some of which are very small. That's all.
And then this is Sammy to answer Hermine's question. Basically, HLO drafted the rule based on what we heard the board say, which is feedback from the public, and then the board trying to get to more specificity around an entity, which is number 1, and then just kind of clarifying who does what as option 2. The board looked at those 2 things back in April of 2022 and said, we want the RAC to talk about it. We're not going to pick one. So they looked at it. They said it's a lot of information. It did answer the questions they wanted to answer in the 2 different options, but they wanted the RAC to weigh in and come up with something. That was what they wanted you guys to do. So they handed you the baton to make recommendations.
Thank you, Sammy. So just like, just forgive me if I'm asking dumb questions here, but just to be clear, option 1 or option 2 are option 1, we continue to require that one happens through an entity and we clarify what entity means. Option 2, we remove the entity requirement altogether and we allow we keep the requirement of 2 a year, but you can do it with fellow midwives and not necessarily an organization. Is that right? As long as they're outside your practice, and at least 2 of the reviewers must be LDMs. Is it, so am I right? It's really about organization versus not. That's what we're here to discuss.
Yes, correct.
Somebody want to talk about pros and cons?
But Hermine, the other thing is we can propose other options, like OMC is
Absolutely.
proposing this specific option, and you can propose removing the rule altogether.
And so Silke, can you just, and forgive me because I know you guys have explained this multiple times so far, can you just summarize in a nutshell the difference between option 1, like how OMC adjusts that with your language?
We just use different language about the entity. I felt like what was in option 1 is still too confusing. And to me, the emphasis is on the nature of the entity, like that the entity is a peer review or quality improvement organization, not on how many people it is or how it's composed. It's on what the purpose of the entity is.
Well, I mean, so OMC is not a peer review org or a quality improvement org. It's I thought that you existed for the primary purpose of representing the needs and interests of your members.
We do, but we are also a peer review organization and a quality improvement.
But so it doesn't have to be your primary purpose, in other words. It just can be part of what you do.
Like what we said, and that's the reason we put maintains a charter and standards for peer review. Like they would just say, and like, for example, I had a meeting with Desiree, who's the president of the OABC recently, and I shared our charter and standards for peer review because I know OABC is thinking about creating a peer review organization, and like, just that there's something that says this is how we do peer review.
Right. Okay.
And
So just that you do it, not that it's your primary. The reason the organization exists is for peer review and quality improvement.
No.
Okay.
Yeah.
So who's advocating for getting rid of the entity? Okay, Willa. Let's get this going.
And we can do a straw poll. You don't actually have to vote. I can take the recommendations as each of them. If you want to vote at the end to agree to each recommendation, we can. But if you want to straw poll it, I can keep track. If you just want to go through it, getting rid of entity altogether, is that?
Let's just talk about it a little bit. Like, I'd love to hear from those who want to get rid of entity, and a little bit about why.
I didn't raise my hand, but I can speak, or should I raise my hand and stop?
Nope, you're good to go, Willa.
Okay. I think by making, well, here's my opinion. I think by including the word entity, it makes all of us all the time feel like there's one extra step of checks and balances. So for instance, like our birth center might do one peer review with our regional OMC, whatever. And then we might do one peer review online with evidence-based birth, which all of our midwives are part of. And then our next one, we have all the neonatologists from MFM at the birth center doing a peer review, or we might call OABC with some other birth center owners. And, I just think allowing us to be competent enough to choose whomever we do our peer reviews with each time feels like a certain amount of respect. And I think that I think that we're all smart enough to know which entity or which group of people are going to be able to help us grow the most, or help us learn the most of our error or our good moves or whatever, you know, happened or whatever we're reviewing at the moment. I think it gives us the autonomy that we all crave as LDMs ourselves, instead of feeling like we have to check off another box, I guess. I'm not sure I'm saying that appropriately enough, but I just think it gives us some freedom and recognizes that we all realize we need to peer review, and we can choose whom we peer review with the most appropriate time each time.
Do any other midwives have an opinion?
Go for it, Lennon. And then Nora.
Okay, here, I'll lower my hand right now. I mean, I agree with what Willa just said. And I would just add that having the requirement of it being an entity, all that that's going to do is supposed, you know, create this requirement where you have to show up to that peer review once a year, but that doesn't mean they're going to necessarily be peer reviewing in that space. Unless, you know, even if it's a sentinel event, you're still, you know, permitted to kind of create your safe space, as Silke was saying. So all you're kind of doing is jumping through. Like, I'm actually coming up on renewal myself in October, and I missed the last my local regional meeting / peer review back in June because I was at a birth. And I was really nervous about missing the one this month, which I managed to make because I have a lot of births this month. And so that was a big stress for me to worry, like, wait, I haven't gotten my entity peer review in yet this month, or this, you know, before I have to renew my license. I was even considering like becoming a member of MANA again, renewing my membership to MANA again, just so I could participate in their online peer review, because I didn't know what else to do if I ended up being at a birth. So I think that, and it didn't mean I didn't have anything I needed to peer review. It's not going to create midwives that are going to necessarily peer review their cases at the entity peer review, but it mandates that they show up, which I guess could be good because it gets them involved. Most of the time it is with the OMC is usually the entity, I guess, for most people. But you know what I'm saying? So I guess that's all I would want to say. It's just that that's like a factor to consider. Like, it doesn't mean they're going to show up and actually peer review their cases there. They're just going to have to now figure out a way to make sure they make that once a year. And it just kind of adds an extra stress, which is what I just went through. So.
Take it away, Nora.
Thanks. If I'm scrolling up and down through the current rules, option 1 and option 2, and keeping them straight, I believe option 2 is pretty much the current rule with better language defining what things mean. Is that correct? Like, yes. Option 2 doesn't have the entity, although the current rule does. So option 2 actually kind of goes back to a blend of the current rule and the 2019 rule, in that there's still 2, but they're not 5 peer reviewers and an entity one time. Is that? If that's the case, that's what I support. Yep. I vote for option 2. For the reasons aforementioned by other midwives, it is one more thing to have to keep track of doing and pay to potentially be a part of, and worry about your licensure coming up and have you done that piece. And maybe not. Maybe it's very easy now with OMC doing twice a year, but not all midwives are comfortable in that setting. And so I really want to not alienate those sisters that are not, those people, excuse me, that are not as included in that for whatever reasons.
Okay. Oh.
I was just going to suggest, I really want to make sure we have time to get to the TXA and fetal growth restriction conversations. And so it seems like we have actually 4 options. We have option 1, option 2, the total removal of the requirement, or what OMC has proposed. And it seems like, you know, the board will get to hear our whole hopefully hear our whole discussion. And it seems like just taking a poll of where we are at might be a good conclusion. I also just want to say that this idea that people need to feel comfortable in peer review is always kind of troubling to me. We need to have basic safety from discovery, safety from someone going outside of the agreement, whether it's an entity peer review or a not peer review. But peer review can be uncomfortable and should be uncomfortable for all of us sometimes. And I think this like entitlement to comfort is actually one of the problems that happens in midwifery. Like, this is uncomfortable work. It's uncomfortable to be as responsible for people's like health and well-being as we are. It's uncomfortable to be stretched between rules and the autonomy of birthing people. It's an uncomfortable profession, and that I feel concerned at the idea that people need to feel comfortable to participate in peer review. So can we just do a poll?
So I'm just gonna do we want to recommend, I mean, it sounds like we're gonna have several, just give them the option. Do you want to give them prior to 2019? Or scratch that one?
I couldn't tell if anyone was still recommending the total removal. Hermine, you were originally talking about like going, having an option that's making the statute match the way that it is for other licensed provider types. So I wasn't actually thinking about before 2019. I was thinking about like one of the options being match other license requirements, which would mean not having a requirement.
If I can respond to that, Sammy, yes, I would like to see an option be to make them match. But I would also suggest that as you're taking the poll, maybe we can do it that that we can choose more than one. You know what I mean? So like, I would like to suggest that they consider making the peer review requirement no more onerous than for LDMs than it is for other license types. But if they're going to go with option 1 or 2, I have an opinion. You know what I mean? And so I would love for us to be able to just deliver all that to the board.
We can do rank voting like in real democracies.
Perfect.
So total removal or aligning with the law, I think would just be this: pursuant to, you must participate.
Yeah.
I think it's pretty simple. So that's one. Sounds like we're not going to do anything prior to 2019. That's out. Out.
Yeah.
Get it out. Remove just the entity piece, which
is option 1.
is
option 2. Sorry.
Option 2, right? Or the OMC option, or option 1, which defines entity further, more. Is that all of the options?
I have an option, which is to rewrite it so that healthcare facilities like birth centers are able to do internal reviews like other healthcare facilities, make the call when to do it, get the feedback for themselves, and that for independently practicing midwives that you keep the entity option, because then that gives them an organization through which they have the capacity to come together for confidential peer review. I think that could be an option.
What would that look like?
I mean, I think it could look like taking, so say, okay, I'll comment on the entity piece. I see a value to an entity beyond a group of midwives. There's going to be a huge amount of variability. And I think Willa's point is very well taken. Of course, I agree that midwives, can be trusted, and yet many of them are on a learning curve with what is peer review. They haven't worked in a facility where this happens before. I think entities facilities and entities can provide a frame for peer review that I think is harder to create for independently practicing home birth midwives, such that I would recommend at least keeping, I don't know if it should be a mandate or an option, and I would throw that back out to the group, but at least an option for entity peer review for home birth midwives seems valuable to try to create that container. And so then I guess to answer your question, Sammy, about how do you create like a hybrid healthcare facility option and then home birth midwife option, I think you just write it into the rule for freestanding birth centers licensed under ORS blah, blah, peer review looks like, and then mirror that onto the rule that applies to MDs working in healthcare facilities or to healthcare facilities themselves. And then for LDMs practicing outside of those facilities, they must do X. They have to participate in it this way. And I think either option 1 or 2.
I want to make sure I understand. You want the LDM rules to require birthing centers to do peer review and or doctors?
The LDM rules speak to LDMs who work both in the healthcare facility setting and in the community setting independently. So I think the LDM rules, they're speaking to LDMs, of course. They're not regulating birth centers, but they can say for LDMs that are working in freestanding birth centers licensed under X, they will participate in peer review within their facilities, and we could either mirror language, or we could point to the language for healthcare facilities, which already describes it. And so LDMs in those settings will do peer review under the healthcare facility rules. And then LDMs that are working independently and don't have access to those kinds of facilities could be offered another structure for peer review, whether that's option 1 or option 2.
And you're speaking healthcare facilities under the Melanie Brunel's oversight, I'm assuming?
Well, I guess Melanie oversees all healthcare facilities, but I guess what I would reference,
they're different.
Yeah,
so hospitals, surgical centers is different, birthing centers is different.
Right, but all of them are under the umbrella of healthcare facilities in the state of Oregon. And I've cited earlier in this conversation, and I can again, the specific rules that make clear. Yes, I will. Here, let me just find my correct document. So again, I want to point them to ORS 441020, ORS 441098, OAR 333 076 and I could do some more.
I'm trying to type, so let's repeat the.
Oh, I'm sorry. 441020, 441098.
Got that.
And then switching over to the OARs, we're in the world of birth centers when we're in 333-076, right? So 333-076-0450. So all of these reference birth centers as being one type of healthcare facility in the state of Oregon. Mm-hmm. And then the rules, ORS 441055 sets the standard for peer review for all healthcare facilities. That includes birth centers under those laws I've just cited. So therefore, the healthcare facility that is a birth center should be able to do peer review for the provider types of L&D services without having to have a discriminatory process for the LDMs within that facility. And so, I would suggest that this board consider, for birth centers licensed under X that are healthcare facilities, they look to the healthcare facility peer review law 441055 for all their provider types, including LDMs. And then whatever that we're doing here applies to those who work outside of health facilities.
I guess I have a concern about that, which is I actually think the same factors that apply to LDMs working in the home birth setting apply to at least most birth centers. They're very small practices. And I think even the largest birth center in Oregon really benefits from getting input that is outside of the practice. And the main part of this requirement that seems relevant is that there needs to be review with people that are outside of the practice so that there's that cross-pollination. I mean, I just think the largest birth center is still very small to do quality improvement solely on its own.
Can I speak to this as a birth center owner? Okay, so peer review at the birth center. We do about, we by no means have one of the busiest birth centers in the state. We do about 120 births a year. And I would say we've always invited all of the home birth midwives that are wanting to come to the peer review at the birth center to our facility to do that. Whether they choose to come or not is up to them. But being a decently busy birth center, which if you ask my midwives, they would say they're running ragged, so they're very busy. We automatically have these really in-depth relationships with every other type of care provider that we refer to and work with every day, being so busy. And so our peer reviews, most of the time at the birth center, already include whoever our receiving OB was and whoever we dealt with in the NICU or MFM. I mean, tomorrow, for example, I'm doing a debrief with the NICU and all the neonatologists from a case. We automatically peer review, and on every case, whether sometimes an OB might call us and be like, hey, have y'all ever seen this at a natural birth? I mean, it is a natural step of the progression of the providers that we deal with. And so then inviting the home birth midwives to the birth center to peer review with us, they also get introduced to those other relationships they might not otherwise have. But it's not imposing upon us who already don't have time to block our schedule to be like Nora said, or no, Nora, it wasn't you, I think it was Sarah, who was like, I couldn't get to the last OMC meeting. It's almost impossible for any of my staff to do the same thing.
Yeah, I'm not talking about an OMC meeting, but
right.
I
Peer
think
review.
that's wonderful that you do that, and there are birth centers that don't invite other midwives to their peer review. And I think you know, we are. I don't mean that we're not busy. I mean, we're small enough practices that even a birth center, even the largest birth center, doesn't have more than 6, 7, 8 midwives in Oregon, and it's about the learning from different perspectives that I think is, and I do think it's useful to have a ground floor standard in the law. I just keep noticing that we're cutting into the time that I think is allotted for the TXA and the other thing. So I wonder, it sounds like what you're saying, Hermine, is you want an additional option that makes some kind of designation that the requirements for the birth center LDMs would be around peer review would be separate and just referring back to the facility peer review.
That's what I was suggesting. Thank you.
And just for birthing centers? Okay.
That's the proposal.
I would also
just
say,
for LDMs at birth centers.
Right. And when we already have a separate set of laws that we practice under anyway, so it wouldn't be anything new to have an extra thing put in our extra set of laws over those that practice at home.
So in terms of being able to do ranked choice voting, it seems like maybe, I don't know, Sammy, if you're wanting to do a poll, but it seems like we might need to run the poll twice, where we run it once and that's designated the first choice, and then we run it a second time and everyone can put like a second choice. Or are you wanting us to just do it verbally and where you would take notes about it?
I think we should do whatever is easier for the board, and I'm not sure what that is.
Sometimes it can be hard to record a poll. Like if you do it in a poll in the Teams meeting, it can be hard to get that to register in. So here, so we are going to do our first choices. And the options are remove the requirement, just where it's just the statute and not additional to that. Option 2. Is anyone supporting option 1 at this time? I'm just trying to make sure we're not voting on things that we don't need to vote on, because I haven't heard any support for option 1. Okay, so removal, option 2, OMC's proposal, and then Hermine's proposal around separation of the requirement for LDMs who work at birth centers. So those are, so whose first choice is total removal? And you can raise your hand so Sammy can see them all. So in round one, we have 1 for removal, and whose first choice is option, so lower your hand again, Hermine. Whose first choice is option 2?
And I'm just clarifying, option 2 is removing entity, correct?
Removing entity. And it looks like we have 3 for removing entity. And then lower
It
hands.
looks
again.
like there's 4.
Oh,
Sorry.
donation. Okay, great, got it. And then option
I didn't know
3.
who that fourth person was. You guys got to let me keep up here.
Yeah. So then OMC is
Wait,
the
so I got Lennon, Sarah, and Denisha for what option 2.
and Nora.
Nora.
Okay. So hands down again. And then the next option is OMC, and OMC is option, which I'm voting for.
That's the one I meant to vote for. I got confused about the options.
Okay, so it's actually 3 for option 2 and 2 for OMC.
Who was the person that just talked?
Sarah Dinger. And then the last one is the proposal of separating how the requirement is for LDMs at birth centers. And no one is left to vote for that as their first because they've already voted for something else as their first.
Seems like the most difficult way to present to the board, but I will do my best.
Willa, are you saying you want to change that?
No, I'm saying I thought we were voting for 2 things. And so I voted for 2, but I don't think it got recorded, Sammy, or 4. 2 or 4 was my vote.
So for your first choice, is it 2 or 4?
My first choice is 4.
Okay, great. So then we'll do the second round, and then you'll do your second choice. And just so you understand ranked choice voting, you can't vote twice for the same thing. It's if your first choice doesn't win out, what is your second choice? So, second round, whose second choice is total removal? Oh, I don't mean to have my hand up right now. So Lennon, that's your second choice. And then whose second choice is option 2? That's my second choice. And Willa's and Sarah's. All right. And then lower those hands again. Whose second choice is the OMC option? None. And then whose second choice is the differentiation between birth center LDM requirements and home birth LDM requirements? Nora and Hermine. And Denisha, did I miss your second choice?
No, I didn't think I was supposed to vote again if the second choice was already. Is that correct?
So you get to say what your first choice is, and then if that one didn't pass, what your second choice would be.
Okay. My second choice, I think, is 4.
Okay, great, got it. Thank you. Sorry, that was complicated. And Sammy, if I wrote that all down, if you happened to not get it all.
I think I got it.
Okay.
So this is what you want me to take to the board?
I mean, along with this entire recording and notes for the whole meeting.
No, of course.
Yes.
But this will be the gist of the recommendations I give them, your first choices and your second choices.
Because it's really important for them to understand that there's a really broad variety of input about this with a lot of different, like they need to understand how complex this issue is to be able to make a good decision. Sammy, are you able to stop sharing your screen so that we can see each other more fully?
How's that?
And Nora, do you still have your hand up?
I do. I counted in our first choices 6 responses, but 7 in our second choice. Can someone just summarize in the first vote how many there were in each, and in the second vote how many there were in each, please?
In the first vote, I have 1 for removal, 3 for option 2, 2 for OMC, and 1 for the differentiation between birth center and LDM who do home birth. And then in the second round, I have 1 for removal, 3 for option 2, none for the OMC option, and 3 for the differentiation between birth center and home birth.
Okay, thank you.
So does it work for us to move to the next section? Actually, can we have a 5-minute break?
Yes. I'm
Bio
actually going to call a 10-minute break.
All right.
Okay, 10 minutes and we'll be back. Thanks, guys.